Good afternoon, ladies and gentlemen. Now, familiar update overview and effectiveness of binding financial agreements. Firstly, some statistics. When I prepared the research for this, I was very surprised, particularly in relation to the fact that basically the average marriage, the first marriage, is only 9 years. And of couples live together before marriage. And basically, first marriage, late 20s, early 30s, and divorce, early to mid 40s. So the fact of the matter is, particularly accountants and financial advisors will be in a situation, as will all family members, where you're going to come quite commonly across probably half of your clients or family who are going to have an issue. Either I've separated, what do I do? Or I'm getting into another relationship, protect me. And that's where we become involved. And we work very closely with accountants and financial advisors because the approach we take is a holistic approach, and we encourage people not to go to court. But the fact of the matter is, you can see from these statistics that it's a reality, and that's a reality that is our society currently and has to be dealt with. Now, financial agreements, looking at the bottom aspect there, protect substantial assets prior to entering into a relationship. That's the usual situation, either be it a first relationship prior to getting into marriage or relationship, or a second relationship when particularly one of the parties has generated a significant income, their partner dies, and they want to protect that against future issues of a new spouse or partner, them separating and then taking them to court. Now, an example of the straightforward type arrangement is here. Jill and John engaged to be married. Jill's father Bob purchased the unit in his own name, wanted to gift it to his daughter when she got married. Now, John has got a recent inheritance, and so what we recommend is that they enter into a financial agreement. So Jill will keep the unit and he won't make a claim. John will keep his inheritance, and if they acquire assets together, they're shared equally. So the situation is there that's the common type of arrangement, but it can get far more complicated, but it's a very effective arrangement, and the reasons are as follows. Financial agreements are really three agreements in one. It can be for property settlement, it can be a maintenance agreement so that when parties separate, nobody sues the other for spousal maintenance, which is something that people don't realise, and it can be a superannuation agreement. And what's interesting as well is that when there is a financial agreement, it can include other parties. For example, if there's a self-managed super fund, and I get a lot of assistance from Kieran of our office in relation, especially in that area, the corporate trustee is a party to the agreement, to the self-managed super fund. Now, what I'm particularly interested today is about how the law is now changing and how the courts are changing their attitude in relation to the effectiveness of binding financial agreements. Originally, firstly, with married couples, they could commence, well, they were legislated for in 2000, de facto couples 2009. So it covers de facto couples, same-sex couples, and married couples. Initially, the courts weren't happy about that because it takes away the power from the court. Section 71A, if you've got a financial agreement, the power of the court to make orders is removed in relation to dealing with and finalising property settlements. So if you didn't cross your T's, every T and dot every I, black and black said, see you later, got a problem. There's an interesting change in the law, and it was particularly a seminal case was the case of Wallace and Stelzer in 2013. 51-year-old Mr. Wallace was divorced, met Miss Stelzer, 38. They met in a Sydney nightclub we affectionately refer to as the pole dancer case. Now, they did a binding financial agreement, both got independent legal advice, and the result was that it said if it lasts for 4 years or any part thereof, Mr. Stelzer would get $3.15 million. guess what? It didn't last, it only lasted 2 years. So Mr. Malcolm didn't think he got value for money, and so he thought, what do I do? So what they do, and this is the problem with the law at the moment, even though they've amended the relevant sections of the Act, which is 90G for married couples, and there's another section for de facto couples, that's the grounds for which, they're the things you have to show to make it binding. What I haven't included is the exceptions to that, and so the court has, well, the legislature has watered that down. However, what people use and what Mr. Malcolm tried to use was the second thing: each party provided with independent legal advice before signing the agreement about the effect on their rights and the advantages and disadvantages at the time the advice was given. So what's still contentious is the fact that Mr. Malcolm relied on various reasons. It's quite an entertaining case to read. However, in effect, he sued his solicitor and sort of set it aside that I didn't get proper legal advice as to the advantages and disadvantages at the time the advice was given. So what the court decided, which is very important, and in fact it's led then to legislation being now in the federal parliament to endorse this approach of the court, is that what's important is that the advice has been given. In other words, provided with independent legal advice before signing about the effect on their rights. End of story. Don't look behind the advice, which is the advantages and disadvantages. So the proposed legislation, which is currently in the Parliament, which is that, the Family Law Amendment, etc. Act, Bill, sorry, it's not an act yet. It's very important, the explanatory memorandum, because it's to reinforce responsibility of the parties to look after their own affairs and not the court, and finality. So the court found that the advice was sufficient. They didn't go behind it. They said the effect of the advice was appropriate. So that case was lost, and Ms. Stelzer did quite well. So the situation is now that that's the current situation in relation to the matter before the Parliament, and it's very effective because why the courts have done this, when it first started they were very protective, but now the courts are so under the pump. They are under-resourced. The Federal Circuit Court in Brisbane and the Family Court is just totally under-resourced. So a lot of people still take the view that let's go to court, I'm really cranky with the other party and let's resolve it there. Now that's totally the wrong approach, but if you do that, you can see there, on an average, from start to a final hearing is 2 years, but because the judges are so busy, you then wait another 6 to 12 months for a judgment. Now, who wants to do that? So, Bill Potts, the immediate past president of the Law Society, there's a very good article he wrote that summarises the current stresses the court's under in the Courier Mail, I think it's 11th of February last year, and I recommend you read it. So the courts are aware of their own stresses, and so that's why it's showing through now in the court's decisions that they're saying, well, let's make these agreements effective, let's not knock them over, because let the parties be responsible and let them resolve their own issues. And that's what's happening, and in fact that's what we encourage, because oftentimes I file an application to the court on behalf of a client, you spend the money on the application, well the client's money, on the application, the affidavit, financial statement. With a bit of luck you'll get a mention date 3 months' time, go to a directions hearing, do financial disclosure, valuations of assets, that's where we get the accountants involved, and then it's compulsory mediation. The Family Court was the first jurisdiction in Australia in 1975 to introduce compulsory mediation. Extremely effective tool. So, but also, so we normally walk into court and we've agreed all that, so that's 3 months wasted, a lot of money spent, and then you have to go to compulsory mediation. And what's interesting is, in every case, the judge sits the lawyers down, clients stand up, and what the judge says is as follows: I don't know why you're here. You've got your own issues. Why you've come to me, I don't know. I don't know you. I'll do my best. But isn't it best if you try to resolve your issues yourselves? So I really hope you do. But if not, you'll come back after if you don't sort out in the mediation, and I'll order a trial and I'll see you in 12 months, and then I might give you a decision another 12 months after that. That's what they say, because they're impressing upon the parties that it's their responsibility to resolve it. And in fact, 9 out of 10 matters, when they go through the court process, don't go past the mediation. But the cost, even up to that stage, is closer to 20 to 25,000. Whereas, in fact, as a qualified mediator as well, I've always taken the view that you've got to educate your clients, and immediately I get a matter, I say, well look, here are the issues, let's get the accountants involved, let's get the property valued, let's then talk about a mediator, and then let's mediate and resolve it. That process, and I use it quite effectively and quite often, can take 4 to 6 months. The matter's resolved, everybody's happy. And in the mediation, they get the chance to vent their issues in a controlled, confidential environment, and it's very effective and very cathartic and gives a really good result. That's how it should be, and that's what the courts are now encouraging in relation to how you then resolve the matter, finally, and that is that you can do 2 things: consent orders, or you just file an application for consent orders if you just mediate without going to court, or you do a binding financial agreement. I've done 2 matters recently where I managed to settle a matter quite effectively through a mediation process without going to court in favour of my client. I was concerned in relation to whether, if you filed an application for consent orders, the court would ratify it, because when you file an application for consent orders, it still has to be approved by a registrar of the court, who's one of the quasi-judicial officers. So we agreed to do a financial agreement, because it's got the same effect as a court order. Stamp duty exemptions, they don't have to be fair, and that's very important too when you talk about non-conflictual matters where there's a situation where one party's got massive assets, they're going into a relationship later in life and has got a young partner. You can do that as long as they get independent legal advice, and as long as the particular requirements of the Act are followed, and it's not difficult to do as long as it's done properly and by appropriately expert lawyers. And that's the problem we have often, that we get people who think they know family law and they make a mess of it. So you can protect ownership of special assets, it's time and cost effective, it's peace of mind, and now with the legislation hopefully to be passed soon, and the courts now encouraging the use of financial agreements, and they're having the same effect, and in fact a better protection, because for example inheritances, Steve was talking about that, and that's a big issue. You can protect your inheritances or your future inheritances. So that's a very effective manner in which to deal with matters. It's a holistic approach, and it's an approach which we certainly endorse, and we work together at Merthyr Law to provide to clients. And the matter's resolved quite quickly and quite effectively, and the changes to the law are very positive and are reflecting firstly the current statistics in relation to the unfortunate situation of relationships, and secondly the courts being so overwhelmed that they're encouraging this process, as is the government. Thank you. Any questions? Yes? Can those financial agreements incorporate a super split? Absolutely. Yes. Sorry, the question is, can financial agreements incorporate a superannuation split? Absolutely. In fact, they are a superannuation agreement. They do have superannuation splits in them, and they're effective. I do them all the time, either with self-managed super funds or accumulated funds. So yes, you can, and it's very effective. As I said earlier, it can deal with property settlement issues, spousal maintenance issues, and it can deal with superannuation splits. Any other questions? Yes?
Can you have a BFA in place after you get married?
Absolutely. Absolutely. You can do it. Well, I'm not sure of the circumstances you're thinking of, but yes, a financial agreement can be completed prior to or during a relationship or marriage, or following a marriage. In fact, what's interesting is that most financial agreements in relation to parties who separate is done during marriage, i.e. before divorce. The old thought, well, people still think that before you can do a property settlement, you have to get divorced, which is not the case. It's a totally different part of the Act. As soon as you separate, you can in fact move toward doing a property settlement, and the sooner the better. So yes, that's the answer to your question. Any other questions? Thank you very much.